بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وبارك على أشرف الأنبياء والمرسلين نبينا محمد وعلى آله وصحبه وسلم تسليما كثيرا أما بعد. Alhamdulillah, today we continue with the Kitab al-Nikah from ʿUmdatul Fiqh by Ibn Qudāmah raḥimahullah, and we began last week with an introduction, essentially discussing some of the ahkam in nikah and how it's performed. And today we go on to discuss the chapter referring to the wilayah, so the guardianship, and the rulings ascribed to that matter of guardianship. And so the author raḥimahullah begins by mentioning Babu wilayat al-nikah, the chapter pertaining to guardianship in the nikah. And he mentions لا نكاح إلا بالولي والشاهدين من المسلمين. There is no nikah except with the wali and two witnesses from amongst the Muslims. This particular statement here is taken from the narration of the Nabi alayhi salatu wasalam, found in the Sunnah, Sunnah al-Tirmidhi, and likewise Sunnah Ibn Majah, where he mentions sallallahu alayhi wa sallam, لا nikah illa bi wali. There's no nikah except with the wali, the guardian. And so what we understand from this as well, like the statement لا nikah, there's no nikah, there's no nikah باعتبار الشريعة. So in relation to the Sharia, there's no nikah in relation to the deen of Islam, the Sharia. And this is what is meant by that. Now, so the nikah is not accepted in terms of the Sharia, except with the presence of a wali. Except with the presence of the wali. And this is the qawl al-rajih, the strongest opinion, the qawl al-jamhur, the opinion of the majority of the fuqaha when discussing this matter of nikah. So they state that the wali is a condition in order for the nikah to be fulfilled, the marriage contract to be fulfilled. Then you have the opinion of Imām Abū Ḥanīfah, where he's of the opinion that you do not need wali for the nikah. And sometimes some riwayat it mentions that this is exclusively for the woman that has been married previously. But some mention as well that he generally says this in general, that there's no wali needed for the nikah. He mentions the reason for this being that a woman is able to carry out business transactions without the presence of her wali, without the presence of her guardian. And so just as business transactions are from the mu'amalat, so is nikah. From the ahkam, the rulings of dealings. So is the nikah. And so due to that qiyas, that comparison that you find between the two, then, or the analogy used, then it is permissible for her to get married without the nikah, without the wali. However, the jamhur, the majority of the scholars, they say that the woman needs a wali. The reason for that being that we have the hadith as mentioned, لا nikah illa bi wali. There is no nikah except with the presence of the wali. And so, in terms of a principle, that if you have al-qiyas fi maqabalat al-nas, so you have an analogy, and the person has derived ruling from that analogy or that comparison, and that ruling is present or it opposes a nas, a text, then of course the text takes precedence. So we have a hadith, and then we have the comparison between a woman doing a business dealing and getting married. So we don't use a comparison, rather we use the direct text, because direct text takes precedence. And so this is why we say that the woman is in need of a wali. She's in need of a wali. And so it's not permissible for the woman to tazawwiju nafsaha. She cannot marry herself off. Now, rather her wali marries her off. And the wali is the one that is the closest in relation to her. And we'll go through the order of the relation. And from the conditions as well is the presence of the shahidain, the two witnesses. The presence of the two witnesses is also a condition. And Shaykh Fawzan, he mentions, لأن هذا من إعلان النكاح. This is from the actions where you find that the person now has publicized and announced the marriage. And so, in terms of the marriage itself, then the wali has to be present, as well as the two witnesses. So the wali, as well as the two witnesses. Now, so the wali has to be present, as well as the two witnesses. It's not a condition that you have an imam, as they say. Now, it's not a condition that you have an imam. An imam that gives a khutbah and delivers khutbah al-haja, for example. It's not a condition. No doubt, someone delivering khutbah al-haja, it's from the Sunnah. It's from the Sunnah of the nikah. But it does not, if the person does not do this does not now affect the validity of the nikah. But what does affect it is whether you have a wali, obviously you need the groom, the one accepting, and you need the two witnesses. So as for the wali, then the author goes on to state, وَأَوْلَى النَّاسِ بِتَزْوِيجِ نعم أولى الناس بتزويج الحرة أبوها. So the one that takes precedence when it comes to marrying the woman off and representing the woman, the free woman, is her father. ثم أبوه, and then his father, وإن على, and if it goes further than that, higher. So if it ascends in terms of lineage. So the first person that has the right to marry off to marry and represent the woman is her father. For whatever reason he's not present, then her grandfather, i.e. his father. Naam. If he's not present, and it goes higher. So for whatever reason, let's say for example the woman, her father's passed away, her grandfather's passed away, but her great grandfather is still alive. Now in this scenario, he's the wali. Naam. In terms of the guardianship, then the guardianship is established as well by way of the father. Naam. So when it states grandfather, it's not the Abul the father of the mother. It's the father of the father. So it's the father, and then his father, and then what ascends after that. Now, ثم ابنها وابنه وإن نزل. Thereafter, those that take precedence is her son. So the son of the woman that's seeking marriage, or his son, and if it descends thereafter as well. So the son, so if there's no presence of a father or grandfathers, then the son, if a woman, for example, she already has a son, he takes precedence. Now, if there's no son, but there's a grandson, then he takes precedence. So likewise, the great grandson, and the like of that. Now, so it's Abu then Jed, if they are present. طيب. So then after that is those that are closest to her. ثم السلطان. Then the sultan. So then it's the ruler. So it's those that are closest to her in relation, then the ruler. When we mention close to relation, we mention it's on which side? Father. Or the son. So the father or the son. Then the sultan, then the ruler. What can be established though is that if the ruler, for example, sees the munasaba, sees that it is befitting to appoint a family member that is not on the father's side, of course from amongst the rijal, the men, then he has the ability to do so as well, if he sees the maslaha. So for example, the woman does not have anyone upon her father's side or anyone on her son's side, but her maternal grandfather is still alive, for example. So the amr is raised to the ruler, and then if he sees it befitting, then he can appoint that maternal grandfather as the Walī. Now we can appoint him as the guardian. And so, in the absence of anyone that is connected to her by way of nasab, by way of lineage, then this amr is received by the sultan, by the ruler. وَيُزَوِّجُهَا, and he is the one who represents her in marriage. And so it's either the sultan or the naib sultan. So that an individual that works on behalf of the ruler. نعم لأن السلطان ولي نعم لمن لا ولي له. Why? Because the sultan, the ruler, is the wali for the one that does not have the wali. The sultan is the wali for the one that does not have the wali. As we discussed previously as well, the ruler is the wali, the hakim, or the sultan is the ruler. This is the wali, sorry. This is, of course, referring to the ahkam in the bilad al-Muslimin. Now, in the lands of the Muslims, where you have an established ruler, Muslim ruler. As for the lands that we live in, the lands of the kuffar, then this role of the sultan is established by the Marakiz Islamiyya wal Masajid. So those that are mas'ul, responsible individuals within the masajid. So for example, a person does not have a wali. And of course, this is common within these lands because a woman may embrace Islam, and she's the only Muslim woman or only Muslim within her family. And so as a result of that, she does not have a wali. And so the Islamic center, the masjid, will establish or will assume the position or assume the responsibility as her guardian. And in that scenario, the na'ib is anyone that the masjid appoints to be in that place of the wilaya. So, for example, you have she's under the guardianship of the masjid. The masjid is responsible for her. The masjid may now appoint a specific individual to be the wali for that particular woman. Now, is that clear, Barakallah? Thayyib. Now, thereafter, Ibn Qudāmah goes on to mention, وَوَكِيلٌ وَالْوَكِيلُ كُلِّ وَاحِدٍ مِنْ هَؤُلَاءِ يَقُومُ مَقَامَهُ. And so the wakil can be appointed, he does this on behalf of another individual, and he's in place of that individual. So it's established in place of that individual. So, for example, if the woman has a father, a grandfather, a son, grandson, for example, and the father says, I'm going to appoint my friend, no relation, this is my friend, to be the wakil or to stand in my place as the wali. Is this possible? Yes? Even with the presence of father, grandfather, son, those that are closer to a relation. Now, so whoever is the closest, if he appoints someone, that person now takes precedence, irrespective of who is present from the awliya of the woman. Does that make sense, Barakallah? So it doesn't matter who it is. Now, then he goes on to mention, وَلَا يَصِحُّ تَزْوِيجَ أَبْعَدْ مَعْ وُجُودِ أَقْرَبٍ. And it's not permissible, or it's not correct, the marriage, so one individual marries the woman, so he's the one that represents her in marriage, but he's further from her in relation, whilst there's an individual that is closer and is present. So, for example, the woman has a father, has a son. It cannot now be a case that the son marries off his mother, represents his mother in marriage, whilst the father is still alive. It has to be the one that is closest, and it's ordinal. So it's in order. And it cannot. This order cannot be surpassed except if the person that is now in place to be that wali, or next in line to be the wali, appoints another individual. It goes on to mention, إلا أن يكون صبيا أو زائل العقل أو مخالف لدينها. Except if that wali, so the next wali is a child. Now, next wali is a child. وزائل العقل, he has lost his intellect. Now, she's not an individual that's regarded as being sane. Or مخالفا لدينها, or he has another religion, he doesn't share the same religion as the woman, doesn't share the same religion as her. So first and foremost, mentions the sabi, bismillah, the child. What we understand from child by the mention of child here is what? The sabi. We mention sabi. Not mature, so he hasn't reached that stage of after puberty. So it doesn't mean now a woman, she has a son, for example, he's 16, 17 years old, and she says he's still a child. He's still a child in terms of qanun, in terms of the laws of this country, but in terms of what is established in Islam, he's no longer a child, no longer sabi. So she cannot now say he's not my wali. Now for him to. Is that clear? Likewise, the one that doesn't have the intellect, it's clear. Or مخالف لدينها. Now, or has a different religion to the woman. So the woman's a Muslimah. She cannot now have her father, who's non-Muslim, for example, the father's a Christian, to be the wali. Naam. Why? Because you have mukhalaf lid-din. So mukhalaf lid-din, if the father has a different religion, then he cannot represent her in marriage. And this is wadih, this is mantaqi, it's logical. Because if the father has a different religion, then it's not possible for him to represent her best interests now in terms of a marriage. Because he's not upon that deen himself. He's not upon Islam. That's really big time. So now if the father's not upon Islam, it's not going to be possible for him to now establish and represent her. Because essentially this is the job of the wali. He's going to represent the woman. It's not possible that he can represent her when he's not upon the deen of Islam in the first place. And represent her in giving over that guardianship to a spouse with the deen of Islam at the forefront in that representation. That's the first thing. What is permissible is for the father, let's say for example the father or this individual, to be a mahram for that woman, even if it's mukhalaf lid-din, mukhalafat ad-din. So even if you have a different religion, you can still be the mahram, i.e. travel with that woman. So a woman, for example, she's Muslim, she can still travel with her father that may not be Muslim. No, he's still the mahram. Because he still enters it within those ahkam of being a mahram. However, he does not enter into the ahkam of being a wali, and the guardian. Now, now, and so as mentioned, there's no wali for the one that has the mukhalif deen. Except for illa Muslim, إذا كان سلطانا or sayyid al-mur'atin. And so the exception to that, mukhalafat ad-din, is if you have a Muslim and he is the sultan, is the ruler. Naam, he's the ruler. Then you're able to have the mukhalafat ad-din. Why? He is the wali. It's established that he's the wali. Naam, as the ruler. So we're talking about a scenario where a woman, she's not upon Islam, and she wishes to marry, but she has no wali. Naam. So then the affair goes back to the Wali Amr. Naam, the Sultan, the Hakim. And so if that Hakim is Muslim, then this can be established. Allah Ta'ala knows best. Clear, barakallahu fikum. Thayyib. And also as well as exception to that is the Sayyid, the master of a woman. So he has a slave girl. In this scenario as well, then it's permissible for him to assume the wilaya. He assumes the wilaya for the slave girl that he owns. Now, so the man is a Muslim and he owns the slave. This is ownership. So then in this regard, we have the wilaya is established, the guardianship is established. Thereafter, it mentions as well وللأب تزويج الأولاد الصغار ذكورهم وإناثهم وبنات الأبقار بغير إذنهم. And so it mentions that the father, he has the right to represent and essentially marry off his children that are young. Naam, whether they be male or female. Naam, so you can represent the male or the female. I marry off his daughters that are yani virgins. Marry them without their permission. Without their permission. It's permissible for them to do so. What's understood from this, barakallahu feekum, is that if there's no known objection to this, so the child does not object. So if it's objected, then this is the person is being forced against their will, essentially. But there's no known objection. And then the father, and specifically the father marries or represents one of his children in marriage, then this marriage is one which is valid. It's a marriage which is valid. Now, the proof of that is the marriage of Aisha, radiallahu anha, al-Mu'mineen, the Messenger of Allah, sallallahu alaihi wasallam, where her father, Abu Bakr as-Siddiq, radiallahu anhu, married her to the Messenger of Allah, sallallahu alaihi wasallam, when she was 6 years of age. Now, with this, we understand that this particular matter is one where we say, of course, it has to be where there is no known any objection. And this is why we mentioned as well, or we discussed previously, an example where if now an individual was to say to another that he marries his daughter to him, whether it be he's being serious or whether it be in jest. But he says, he was to say to so-and-so, I marry my daughter to you. And he mentions his name. And that person says, I accept. This is I accept. And he says it in the presence of witnesses. At least 2. Then what? He's married. He's married. Why? Because it fulfills all of the conditions of marriage. Naam. And the idhn, naam, the permission is not a condition. The permission is not a condition for sihat al-nikah. And rather, these things occurred. These things have occurred. Naam, where people may be joking with one another, and then the joke goes too far, basically. Where a person jokes with one individual and says to them, yes, I marry my daughter to you, O Falan. And they're in a gathering. And within all of the laughter, the ha 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 ha, he says, I accept. Naam. This is and so the Messenger of Allah sallallahu alaihi wasallam, he mentions that there are 3 matters. That when they're said in seriousness, they're taken seriously. And when they're said in jest, they're taken seriously as well. Naam, the 3 matters being nikah, naam, being the divorce, the talaq, and the raja' al-dani, the taking the wife back. All 3 of these are said, and once they're said, that they are taken seriously and established, and ahkam revolving around it are established. Allah Ta'ala knows best. So now, it mentions that this is what is sought in relation to the child. ويستحب الاستئذان البالغة. And there's mustahab. It's recommended that the permission is sought for the woman that is baligha. Remember what we mentioned previously, we were referring to the child. Now we're referring to the one that is baligha, the one that has reached the stage of puberty. Now, as for the baligh, so the baligha referring to the woman that's reached the stage of puberty. As for the baligh, as for the man that's reached the stage of puberty, then the father does not have the right at that point to represent him in marriage. Naam. Except for what? If he appoints his father now. So if he requests that, for example, or he appoints his father in that place. Now, nor Does the father have the rights to marry or to represent his daughter in marriage if she is thayyib? Thayyib referring to the woman that has already been married previously. Now, except for with their permission. And so this particular ruling is specific to the father. So these rulings are specific to the father and not the rest of the awliya. So the other individuals may be awliya, they may be regarded as guardians, but it does not now necessitate that they are able to establish this marriage without the permission. Now, is that clear, Barakallahu fikum? So, without the permission. So when we say we mentioned the permission, the permission is sought, or permission does not have to be sought when? Does not have to be sought. When they're when they're a child, before puberty. Now, male or female? Both. So after puberty, permission is so permission is not sought from the son. It's the opposite, he's saying.
Permission is needed for the men, now the men, but the permission of the girl is needed because she's not married yet.
So the permission of the daughter is not needed, but is mustahab. The permission of the son is needed, i.e. to seek his permission. Now he has to permit it. Now, sahih. Just the son? And the thayyib. Now, the one that's previously married. So, and this is a right afforded to who? The father only. Now, exclusive to the father. Barakallahu fikum. Now, as for the idhn, as for the permission, وَإِذْنُ الثَّيِّب الْكَلَامِ وَإِذْنُ الْبِكْر الصَّمَاتِ. As for the one that's been married before, then they have to give their permission verbally. Now they give their permission verbally. As for the afwan as-simat, then, or the bikr afwan, then her permission is as-simat. Her permission, she can suffice with silence. Now, so this is the difference between the two. You have the thayyib and you have the bikr. Does anyone know the definition of the thayyib? Definition. Because we're saying this one has to say something. So when do you become? When do you enter into that stage where you're now a thayyib and you have these ahkam upon you? Past puberty? No. Married before? Okay. Not man, because we're talking about in this case, the woman. So the female woman. Her permission is silence. We're saying the thayyib though has to speak to give permission. The female woman. Or the female now. So this is the difference. It's not only is it first and foremost, it has to be a nikah sahih. So they have to have entered into a nikah sahih. So the thayyib we're talking about, the definition of thayyib. Nikah sahih, and they have to have consummated that marriage. Now had marital relations essentially, barakallahu fikum. So then these are the conditions. If these conditions are not fulfilled, then it's not necessarily regarded that they are thayyib. Naam. And the ahkam surrounding that, may not be relevant. Does that make sense, barakallahu fikum? So as for the one that is bikr, then she can suffice with her silence. Can she mention her permission though? Out loud? No, she can. So she is not now bound by silence. She can mention permission if she wishes to. No. Sometimes you find that's what happens as well, is that if they ask her um and then she may be asking a greater setting, a bigger setting, and then she feels that the silence is even worse. It raises the tension of the situation. She wants you to say it to end the tension. But a moment this ruling is there because obviously what's understood from this situation is the bikr will have a degree of shyness that is more so than the thayyib. And so with that, as mentioned, you can suffice with her silence. Likewise as well, it mentions وليس للولي امرأة تزويجها بغير كفئها بغير رضاها. Now, so here it mentions the مسألة al-kafa'a. Well, kafa'a is referring to the wali or the woman having a similar status to the husband, that they are similar in status. Now, is that clear, barakallahu feekum? That there's no large difference between them. So what it mentions here is that it's not for the wali to marry Naam and to represent the woman and marry her to an individual that is not of the same status. So this is referring to the nikah where they are equal. There's some degree of equality Naam when it comes to nasab lineage. Naam or mansab position. So someone can have a greater position in society, then the person should seek to marry that individual to someone that's in a similar position, especially with her approval. If she approves of anybody, so she doesn't mind in terms of the person's lineage or position, then what is understood by way of that is that the marriage is valid. Does that make sense, Barakallahu Feekum? Marriage is valid. Then also goes to mention, well, Arab بعضهم لبعض أكفاء. And he mentions the Arab, for one another, they are similar in status. This is based on this statement here is based upon the opinion of some Ahl al-Ilm that there's fadl of the Arab over the Ajam. So there's fadl as the virtue is with the Arab over the Ajam. Those are the non-Arab. Naam. And so what is understood from this is that it's not now fulan, one individual min afrad is better than one individual from afrad from the Ajam. Now, one individual is better than this individual that is non-Arab. What is referred to is in general. Now, a generality of it. Now, and Allah Ta'ala knows best. This is what he mentions here. Likewise, when it comes to the equal standing, then of course it's referred to as well the abd. Now, the abd, the slave should not be married to the to the free woman, because of course their status is completely different. One is owned, whilst the other woman, or the woman in this case, is free. Now, and now the slave, as you mentioned, the abd, he is mamluk, he's owned, and so he's not able to perform any particular action or certain actions except with the permission of his owner. Now, except with the permission of his owner. And so this is the relation to the slave. Thayyib. Likewise as well, the fajr should not be married to the afifa. So you have an individual that is a fajr, an evil individual, a wrongdoer. He should not now be married to the one that is chaste and pious from the women. Why? Because there's a clear distinction between the two in terms of the level, in terms of the standing. But now we're talking about standing in terms of diyana, religiousness. Along with that as well, from the reasons, is that if now you was to marry the chaste woman, the upright woman, to the fajr, the evil man, then what is a great possibility that will occur? He will draw her towards what he's upon. He will influence her in what he's upon. And so this is something which is vast as well, or something which is more than just or something which covers many different things. For example, you wouldn't marry now as a Walī, you wouldn't marry your daughter or your mother to someone that is not Salafi. Now, I'm not upon the Sunnah. Because, of course, if we're talking about fisk and wrongdoing, then of course bid'ah is from that as well. Now, you wouldn't marry the person to that. Why? Because the woman essentially, for the most part, is going to follow the man and what he's upon. And so if she follows him, then she'll follow him upon his bid'ah as well. So something which is, this particular hukum is one which covers many different things, not just that the person is, for example, just a sinner in general. But it could enter into the matter of bid'ah and the likes of that as well. Allah Ta'ala knows best. Now, so thereafter, Ibn Qudāmah goes on to mention, وَمَنْ أَرَادَ أَنْ يَنْكِحَ امرأة هو وليها فله أن يتزوجها من نفسه بإذنها. And so he goes on to state, and whoever wishes to marry a woman and he is her wali, then he's able to marry her to himself. Naam, with her permission. He has to marry her to himself with her permission. Does everyone understand the scenario, how this could occur? That's further. She's an orphan now. So she's an orphan. And he's raised her. But even though he's raised her as the orphan, there's no alaka, there's no relationship between them two. Now, so it's not haram for him to marry her, essentially. It's not a mahram for her. Now. And then, in this scenario, what would he do? Now, he seeks permission and then he marries her directly. Now, so he marries her to himself. Now, so likewise as well, if a person wishes to marry the amma, so the slave girl or the slave, the female slave, to the abd al-saghir, to the young slave boy, then in this scenario as well, he represents both sides. He represents the boy and he represents the girl. Now he represents the slave. Does that make sense, Barakallahu Feekum? Why? Because they're both mamluk. The mamlukani. They're both owned in this regard. So he, as the owner of the slave girl, is the wali, and as the owner of the slave boy, he can represent him in this marriage contract. So this particular scenario, he would be the wali for both. Naam. So likewise as well, and we go on to mention some of the rulings regarding entering into slavery and the likes of that. Well, of course, we know that this isn't something which is very common, or see it at all now. But I call it bab faida. It mentions as well that if a person has a slave girl and he wishes to marry her, then he may make her freedom the sadaq, her mahar. So her dowry is her freedom. So a person has a slave and he wishes now to marry her. He makes he states to her that I've made your freedom your dowry. And he says this in the presence of two witnesses. Naam. Then with that, her freedom has been established as well as a nikah. Does it make sense? So he says that I've made your freedom the dowry. I've established that your freedom is the dowry. With that, it establishes the freedom and the nikah. Now, as long as there are two witnesses present. And this is established by the action of the Messenger of Allah sallallahu alaihi wasallam during the Battle of Khaybar, where he freed Safiya radiallahu anha, and with that, giving of her freedom, this allowed him now to marry her as well. Now it's allowed him to marry her. Allahu Ta'ala A'lam. And we'll conclude here, inshallah, with that. Or just mention that was the last point, sorry. ومن نكاح ومن نكح أمة على أنها حرة ثم علم فله فسخ النكاح وما راح مهر عليه إن فسخها قبل الدخول ولأصابها فلها مهرها. So if now a person marries a slave girl with the assumption or with thinking that she is a free woman, and thereafter he discovers that she is a slave, then he has the ability to annul that marriage. He has the ability to annul the marriage. Now, and if he has not consummated that marriage, then he is able to annul it without giving anything of the mahar. Now, anything from the dowry. However, if he has consummated that action, then he has to give her the mahar. And that's now the main point in relation to, or the last point was to mention in relation to that. Jazakumullah khaira wa barakallahu feekum. And now, in relation to last week, just want to clarify a point in relation to last week, where we were just discussing the matter of approaching the woman, whilst she is in the iddah. And what did we mention? I don't remember what we discussed. I don't want being approached while she's in the iddah, the iddah period. You can't ask her hand for marriage. In what way? Directly. You can't ask for marriage directly. Now, but what can be done? Now, indication. This, just to clarify, this is referring to the final talaq. It's the woman that is mutallaka, talaq ba'in. So she has that final talaq. Why? Why is it not the first or the second? No, so she's still married. In that first or second, so if the husband divorced her the first time or the second time, that in the period, the husband is still permitted to take her back. And so with that being said, it's not for anyone to approach her. It's just the same as approaching a married woman. If now the man has divorced her for the third time, then can the husband take her back? No. Can she be approached for marriage? Not directly. But what can be said? No, that I want to. You seem like someone suitable to me, or can I like this? No, but he cannot now say directly that I want to marry you. No, because speech like this would constitute being a proposal, and of course, a woman that's in her interpret cannot be proposed to. No, so this is just the clarification I want to mention. Jazakallah khairan. Wa barakallahu feekum. Regarding that matter. No.
Two questions. One basically from last week, which is during the divorce, does it require a witness?
So divorces do not require witnesses. Marriage requires witnesses. Divorce doesn't. However, it's better to have witnesses. Now, why? No misunderstandings or disputes at a later stage. Where a husband, what you call person is not mustaqim. And he says, no, I didn't divorce her. He rejects the whole thing. And maybe for whatever reason she can't fully remember. No. Or they both conspire to lie. No. But if you have the presence of witnesses, obviously two witnesses that are upright, then that removes all of that. No. But it's mustahab, it's not a condition. Like, for example, if a person was to state the divorce to the wife, and it was just them and two in the home, then it's still a divorce.
Based on that, what if the man now divorces and his wife saw it coming, so she covered it in the one? Is it still considered a dollar? Yeah, I can ask. So he's about to divorce her. She noticed it, so she covered it in the one.
No. She covered the ears and ran off. Yeah. So he was going to divorce her, and then she kind of saw it. She could see it was coming, and then so she tried to make sure she didn't hear it. The ibra when it comes to the mention of divorce is the kalam, the love. So it's not necessarily who heard it or whatever else. A person could say to his own self, they divorced his wife. Now, so the person could say to another friend, they divorced his wife. Now, and she's not present, she doesn't hear it. It's not a condition that she hears it. Now, of course, a lot of the time it will be something that she hears. Why? Because the reality is it occurred, a lot of divorces will occur in arguments and back and forth. It's not a condition. In order for the divorce to occur, the person makes the statement upon the tongue. Now, especially if it's sarih as well. If it's a direct statement, whether she hears it or not, is not conditioned. Now,
The final question was regarding about the slave girl must put in the dowry of her freedom. If she was not to get follow, does that mean she becomes slave to him?
Good question. Allah knows best. I don't know. So she was to seek the khula. Yeah, sahih.
So her dowry was her freedom.
Yeah, sahih.
Now becomes servant.
Good question. Allah knows best. I haven't tried it. So no. It's a good question.
Now, man's got a slave girl. He's going to get married. Dowry is her freedom. If you now want to see her full service, she doesn't want to marry him. Yeah,
so her dowry was her freedom. So so now she's seeking khula. Obviously, the general ruling of the khula is that she returns the dowry. The dowry is her freedom. So now in this case, does she become enslaved again? I don't know. No.
That's why I got a question. So who is the Walī of the woman after the son and the grandson?
So it'd be the closest male relatives on her father's side. So it would be the paternal uncles, and who goes up from there. So that, as we say, great uncles and things like that.
What about the cousins?
No, because they're not maharim as well.
So what about the brother?
The brother now, the brother and sorry, it could be the brothers, then the uncles. The son, brothers, uncles. No. But when we say brother, we mean who?
Oldest.
No, sorry, the oldest.
Father.
Blood brother? Is there any other type? Is there any other type of brother? No.
Not half brother.
No, it can be half brother, but if it's a half brother, it's on which side? The father's side. No. So it's either your shaqiq, so the full brother, you share the same mother and father, or it's the akh li-ab. The akh li-ab. So the brother through the father. Wallahu a'lam. No.
So a man marries his kids off, the father marries his kids off, and then they mature and they oppose the marriage. How is that dealt with?
If he marries them, then they oppose it in terms of they don't wish to be. They can seek to remove themselves from it. Now they may need to seek judgment from a judge, or other than that, or if it's a case of there's amicable agreement, they can do it like that. The best case, obviously, is amicable agreement. If not, then seek a judgment.
If you now raise a child, you have no relationship.
Yeah.
But let's say the wife breast.
Are you? You're the Walī anyway, because you've raised a child. You're the guardian. Now you have that relationship through the suckling as well. No. So you're related to them through that as well now. No.
So you see, when you mentioned that people can't joke with the statement of, "Oh, I'll marry you, my daughter," and then they accept, this. Yeah. So now, obviously, if the child, like, it's not even a child, or say it's like 16 or 15 or whatever, yeah. And now two friends had that banter.
Yeah.
And then it's gone that way. And then now this individual, the child, says, "I don't want that."
Yeah.
That's become compulsory. How does that work out?
Similar to what the brother asked.
Okay, so
It's a case of
they would have to go to the court.
and seek advice from Ahlul Ilm.
Okay.
And try to amicably solve it. Allah Ta'ala knows best.
Yeah.
But obviously the point being is that the person should be jad fi kalami. He should be when he speaks with seriousness, and not and the person shouldn't joke anyway, but shouldn't joke in those three matters specifically as well, or they're taken seriously. So a person could say jokingly, like we said, "I marry my daughter, blah blah blah, to you for life, for life." The person says, "I accept," it's valid. Likewise, if a person, which is known as well, the person, if they said to the wife in a joking way that they divorced them, this divorce now is valid. Or if the person divorced his wife and he says jokingly that he takes her back, then he's taking her back. No.
Okay. This makes it basically the seriousness of these matters that you shouldn't joke around.
No, it's salam. No, definitely. Barakallahu feekum. جزاك الله خير. بارك الله فيكم. صلى الله وبارك على نبينا محمد وعلى آله وصحبه.